Hello, what's up everyone? Tonight I'm gonna be talking about defenses under Torts 1. So without further ado, let's go. This is the only topic I'll be talking about tonight, so hopefully we will cover it in a short span of time lah. So what are defenses? Defenses are arguments that are raised by the defendant even though the plaintiff has successfully proven elements of negligence, elements of trespass and whatnot. So, in this topic, we'll only be looking at the types of negligence and types of defenses. And then that's about it. Hanya jenis-jenis defenses je. That's it. Okay, there are 10 in total and I'll go through one by one lah. First, contributory negligence. Contributory negligence is the failure of the plaintiff to exercise reasonable care onto himself, and that makes him the author of his own wrong. So because he has failed to reasonably exercise duty of care onto himself, he is partly responsible for any injuries that he has contracted macam tu. So the court will look at whether or not the plaintiff's conduct is on par with the standard of care that he must exercise onto himself. So in the case of Froome against Butcher, the plaintiff must reasonably foresee that if he did not act as reasonably prudent man, he can hurt himself. That was the principle that was established in the case of Froome against Butcher. Okay, so as a result of contributory negligence, the plaintiff cannot claim full compensation from the defendant because the defendant is not fully liable of the plaintiff's injuries. So if part of the injuries borne by the plaintiff is due to his own negligence, then he cannot claim that part lah that he is liable for. Macam tu. He can only claim the part that defendant is liable for and not fully. Okay, this is seen in the case of Sharizan bin Sudirman against Abdurrahman bin Bukit, whereby in this case there were there were two 15-year-olds riding a motorcycle without a helmet and without a license, and a policeman chased after them onto a motorcycle as well, and then the policeman negligently kicked down the kids punya motorcycle and they sustained injuries. So even though the policeman had negligently kicked the kids punya motorcycle, the fact that they had negligently rode the motorcycle itself, which is proven by two things, which are the lack of license and also didn't wear any helmets, that made them contributorily negligent towards their own case. Macam tu. So they cannot claim for the full compensation lah macam tu. Okay. Secondly is volunteer non-fit injuria. This basically says that to one who volunteers, no harm is done. So basically, if the plaintiff has voluntarily agreed in full knowledge of the circumstances of the situation he is being put in, then the fact that he had voluntarily agreed to do such a thing completely extinguishes any liabilities on behalf of the plaintiffs. So this is quite a powerful move lah. If you can pull this off as the defendant, you're absolutely and utterly innocent. Macam tu. So this can be seen in the case of White against Blackmore, whereby there was a jalopy car race. I think it's a type of car race lah. And then there were safety ropes and also warning signs in the track. And then even though the warning sign had stated that the organizers are not responsible for any death howsoever caused, which means that in any way during the race, the plaintiff still went into the tracks and he died. So the fact that he had voluntarily went into the tracks of the race while the race was happening without considering the warning signs makes him fit under the principle of volunteer non-fit injuria. Okay. Third, self-defense. Self-defense is used when the person does not have time or opportunity to call for help. So there are two requirements to raise a self-defense punya defense. First is reasonableness of defense and using violence. So is it reasonable for that person to use violence in his defense, and also the proportionality of violence with harm. So is the violence that is inflicted upon proportional with the potential harm that could come into the defendant's way. Macam tu. So these are the two requirements lah, reasonableness and also proportionality. And as seen in the case of Cockcroft against Smith, whereby a lawyer bit into a clerk's finger in self-defense, that act itself is not proportional with the threat of the clerk to hurt him, macam tu, if I'm not mistaken. So don't quote me on that. Okay. That is self-defense, which is the third type. Fourth is defense of another. This is basically the same as self-defense as mentioned earlier, but in defense of another, there must be a relationship between the defender and the defended. So the defender and also the one being defended must have a relationship. However, in this principle, in this defense, you can also defend a stranger from any danger that or any unlawful activities lah, macam tu. And fifth is defense of property. Defense of property is using force to defend one's property, and this can be claimed by the possessor in fact or the one who has rights to immediate possession of that property. Okay, as demonstrated in the case of Cresswell against Searle, the defendant shot the plaintiff's dogs for chasing his sheep, and the plaintiff had dogs that chased the defendant's sheep, SHEEP. So that chase caused the sheep to have a miscarriage, and he subsequently shot the two dogs because he was worried that something like that would happen in the future. Okay, and then basically the defendant is not liable because he used violence to prevent any harm being done on his property. However, the right to protect land or property does not extend to placing deadly objects. So you cannot place booby traps and all to just in the name of defending your property. You cannot do that. Okay. 6. Necessity. Necessity is relevant for all types of torts. So negligence, assault, battery, false imprisonment, and all that. It applies to everything. Okay. And in the case of Southwark London Borough Council against Williams, it is established that the danger must be imminent or the act of negligence is the danger must be imminent or the tort must be done to save lives. That is the two requirements to raise the defense of necessity. Okay, so there are two types of necessities, private and also public. For private necessities, it is done to prevent greater damage to oneself, and the court will consider whether the person's life is threatened or not in that particular situation. So this is seen in the case of Lay against Gladstone, where the defendant went on a hunger strike, dia mogok lapar. So in order to save the defendant's lives, the plaintiff had to force feed the defendant, and even though the defendant brought the case to court, the plaintiff successfully even though the plaintiff brought the case to court, the defendant successfully raised the defense of necessity and the case was dismissed. Okay. Secondly, public necessity, in which the defendant acts in defense of the community. So in the case of Dewey against White, there were chimneys that caught on fire and they were at risk of falling down. The chimneys were caught on fire, and then policemen, they demolished it, throw it down in the defense of public necessity, macam tu, because it could save lives. Macam tu lah, senang cerita. Okay, 7 is mistake. Mistake can only be used in very limited circumstances, and as you can see in my notes, the elaboration itself, where is it? This one. The elaboration itself is literally one line, so I'm just gonna read from the slide. For instance, if a police officer arrests someone whom he reasonably suspects of committing a crime that can be lawfully arrested, but it turns out that no such crime was being committed, the officer can justify his actions based on lawful arrest. In this case, the mistake can be used as a defense in a lawsuit for false imprisonment. That is basically the elaboration for mistake. Okay, number 8 is consent. Consent can be given expressly or impliedly, and that the defense of duress or threats impair the defense of consent. So that means if you are under duress or you are under threats, you are not freely consenting to whatever it is that you're doing. Therefore, you cannot raise this particular defense. Okay, and this particular defense can only be given after, consent can only be given after the plaintiff knows of the risks that he might go encounter when going into a situation. Okay, so that is only then, only after knowing of the full consequences, can consent be given. Okay, now let's look at consent in the field of let's look at consent in the medical field. Can consent be given? So basically, in the medical field, consent is very important. It's a very important element, and that contact by a doctor without the patient's consent can be a prima facie case of battery. As seen in the case of Chatterton against Gerson, the patient argued they did not know of the dangers of the operation, but the court held that the patient knew of the dangers of the operation, and therefore the case was dismissed. However, one important thing that we must consider is that if the patient is unconscious, meaning to say he cannot give consent in the moment, the doctors can be held not liable if their actions intend to save that particular patient's life. So it's kind of a special case lah senang cerita. Okay, number 9, discipline. Discipline can be used as a defense for battery and false imprisonment, and discipline is basically to punish the plaintiff for any misbehaviors lah senang cerita. So in the common law, the teachers in schools can use reasonable force to discipline students, and the concept of reasonable force is whether circumstances necessitate the use of force to maintain order. So in the case of Ryan against Fildes, Fildes, the plaintiff was boxed, so he got hit by 1-2, I think, and then he went deaf on one ear. So it was held that the blow, that particular punch, exceeded any reasonable correction that can be given. That means this goes back to proportionality tadi lah. Is the violence proportional to whatever it is that is needed in order to maintain peace and also maintain discipline macam tu. Okay, lastly, lawful arrest. Lawful arrest is arrest given under reasonable suspicion, and in the case of Tang and Ho against Attorney General, it is established that a reasonable man would be suspicious of the plaintiff. Okay, bawa balik. Okay, lastly, reasonable arrest. Reasonable arrest is arresting someone under reasonable suspicion. So what is reasonable suspicion? In the case of Tan Eng Ho against Attorney General, reasonable suspicion is when a reasonable man would be suspicious of the plaintiff. So it's very simple. Okay, and also the policeman can also seize the goods of the person in custody to present them in court or to keep them safely so that they can present it in court, and that it can justify trespass of goods. So it can be used as a defense for trespass of goods. Okay, that's about it. Wow, not even 15 minutes for one topic. That's quite good. Okay, that's about it. See ya.